Welcome to the continuation of the case Indira Gandhi versus Narain. This is for Administrative Law, Dr. K. Sangeeta. The impugned amendment tried to make elections of the Prime Minister, President, Vice President, Speaker of the Lok Sabha unjustifiable, which is totally against the essence of democracy. The amendment tried to make the election of most important politician unjustifiable. No matter how much illegitimate their elections, one cannot challenge it, that too in a democracy. The court, however, shed water on parliaments or say Indira Gandhi's malicious amendment and made rule of law to triumph. Prashant Bhushan, who was the co-counsel in state of Uttar Pradesh versus Narain, has written a book explaining the nuances of the case in detail. It the title The Case That Shook India. He has written that this case has proved to vigor of democratic institution of India. This case upheld both rule of law and separation of power. The court made it clear that validation or invalidation of an election is purely a question of judicial nature and it cannot be performed by legislature. Since like a judicial body, legislature cannot find adjudicative factors. Therefore, this transfer of pure judicial function cannot be termed as constitutional. Actually, the pith of substance of the amendment was aimed at reversing the High Court's decision and invalidated the election of Indira Gandhi from Raebareli constituency. This was really a cowardly act to use an important provision like constitutional amendment to satisfy a political exigency. The Prime Minister of the nation, after finding herself guilty of such violation of election laws, should have resigned which would have left dignity at least. Instead, she imposed emergency to serve herself over that passed a draconian law as 39th Constitutional Amendment Act 1975. However, the judiciary came to rescue and upheld the sanctity of the Indian Constitution as well as upholding democracy. The court unanimously held that the 39th Constitutional Amendment violative of basic structure and struck it down. The importance and the after effects of the judgment can be well and clearly understood by the quick passage of the 42nd Amendment Act 1976, which made the challenge of amendment in the court of law impossible. However, this amendment was struck down in Minerva Mill case. The parliament, in its desperation and fury on judiciary, passed a law by virtue of the court lost the power to question any amendment of the constitution. The judgment of the Supreme Court was the first with the basic doctrine was applied to save the constitution from malicious attack. The 5 judges bench, by holding the impugned 39th, proved to be parliament that they are just elections to make laws, that they are just elected to make laws which are beneficial to the people of India and not those laws which are beneficial for them who are holding the power and post. This judgment was a trump to rule of law because once again it was the law that proved to be successful and not those who make it. The apex court proved that law is supreme and it cannot be brought to knees even by the chosen ones. India is the largest democracy in the world. The essence of democratic government lies in the conduct of free and fair election. The parliament tried to mold the basic essence towards their end so that they could not have the prerogative to validate or invalidate elections. One could only imagine and fear the imagination that this regressive amendment would have brought to the Indian democracy. Besides, what is the meaning of democracy? It is for the people, by the people and of the people. If there are no free and fair elections, how this could be attained? The amendment privileged to the specific members of the elections being challenged in the court, which is like stripping a person of his legal right to a remedy. It was very brave move of the judiciary that along with the emergency turmoil it came up with the brave and an important decision where it had proven that Indian Constitution will not bend its knee against any malicious bunch of politicians. The appellate court must be honored for such an important decision against the mighty Indira Gandhi government. Aftermath of Indira Gandhi's case. Parliament, after facing such a severe loss at the hands of judiciary, was so furious that it planned to make the law by virtue of which no court in the future would have jurisdiction to entertain a challenge of constitutional amendment. In pursuance of the above objective, the Parliament amended the Constitution through the 42nd Constitutional Amendment Act 1976, which is always known as the Mini Constitution. The argument advanced against the passage of such a brutal amendment was in twofold, which was supremacy of the Parliament and criticism of basic structure. The proponents of the amendment argued that there are no basic or fundamental provisions in the Constitution and every provision is equal in status for the purpose of the Parliament. This was basically the implication that there is no limitation whatsoever in the competence of the Parliament with respect to its amending powers. Such arguments were in direct defiance to the landmark ruling of the Supreme Court in Kolaknath and Keshwananda Bharati case. Therefore, to achieve the said objectives of the clause 4 and 5, which were added in Article 368 with the following effect. As to clause 4, it was added to make it clear that from this date onwards, there shall be no challenging the court on the issue of constitutionality of any amendment passed by the Parliament. This was to ensure the bar of a jurisdiction of the court to entertain a challenge on the amendment, directly barring the jurisdiction of the Supreme Court. This clause also had the power of validating earlier amendments, invalidating by the Supreme Court, such as the 25th Amendment, which is the second limb of the 39th Amendment, etc. Clause 5 starts with the phrase for the removal of doubts. This clause was added to make it explicit that there is no limitation on the power of the Parliament with respect of its amending competence, implying that not only can the Parliament amend fundamental rights, it can also amend the basic structure of the Constitution. But later this was overruled in Minerva Mill case.